When we're live. Okay, Mr. Ryan, let's go ahead and announce the name and case number on this case.
Yes, Your Honor. We're here on JTJ Solutions LLC versus Eli Global LLC. The cause number is DC-19-16673. We're here on plaintiff's motion for traditional and no evidence summary judgment. And for the record, my name is Andy Ryan, and I represent the plaintiff, JTJ Solutions.
Okay. Mr. Reed.
Good morning, Your Honor. Kendall Reed with Condon Tobin on behalf of Eli Global LLC.
Okay, let's proceed.
All right, Your Honor, I know you're familiar with the case, so I'm going to keep the introduction brief. As you'll recall, this is a case where the plaintiff sold their medical billing business to an affiliate of the defendant, Eli Global. Part of the purchase price was a $1 million note divided into 3 equal payments. Eli Global made the first 2 payments, didn't make the third, and so we filed suit. The court has previously granted 1 summary judgment motion to the plaintiff on all elements of our breach of contract claim, which is our only claim in the case, with the exception of damages. That's the only thing that remains other than the issues addressed in this motion, which are Eli Global's affirmative defenses and its counterclaim for unjust enrichment. I've submitted a proposed order to the court that I'm going to try to track because there are a lot of defenses and the court may grant some and deny others. And so that might be the easiest way to go through everything.
That's a great idea.
I'd also note for the court, while I mean this certainly be respectful of the court's time, when we were last before you, we said we were going to go to mediation. We've got that mediation scheduled now for November 17th. So to the extent we can get rulings on any of these issues today or before November 17th, it probably would help the mediation a lot. I know you've got a lot else to consider, but I'm just letting you know that that is kind of hanging out there. All right, so tracking through the order that was submitted, we've got a little table for the affirmative defenses and then whether the court
So go ahead and share screen the order you want me to track.
Yes, sir. One second, Your Honor. Apparently, I got a new computer. I have to update the security preferences. Just 1 second. All right, Your Honor, apparently for you to be able to see my screen, I've got to quit Zoom and log back in. So if you can give me 1 second, I will do that and I'll be right back.
Okay.
Thank you. Your Honor, this is Andy Ryan. I've returned to the Zoom hearing. Can you hear me?
I can.
All right, I'm going to try to do share screen. Okay, let me blow this up. So, Your Honor, this is the proposed order that is submitted on the no evidence motion for summary judgment, or traditional and no evidence motion, excuse me. I'll go through each of the affirmative defenses in turn. So,
and let me just say, if the other side just agrees to any of these, please speak up so we can kind of go through as quickly as we can.
Well, then let me start with that, Your Honor. It'll take them a little bit out of order, but you'll see 3 affirmative defenses in the middle: unclean hands, failure to mitigate, and justification. Mm-hmm. We moved on those and they weren't addressed in the response. So in the reply, we noted that we believed they were conceded, but the defendant's proposed order suggests the court should deny the motion in full. If those aren't in the case anymore, that may just knock out 3 of them real quick.
Do you guys still contest those or not? Mr. Reed?
Your Honor, we are not pursuing the unclean hands justification or failure to mitigate.
Okay. All right, so those are all granted. And this order that you sent, is this something that you sent to the court, or is this just something that you
It was e-filed, Your Honor, but I can also email it to your clerk after the hearing.
When
if that
did you
would be easier.
e-file it, just so I can look for it?
November 10th, same day as the reply.
Okay, we should have it then. Let me look. All right, go ahead and any others that we can agree to?
I believe those are the only agreed ones, Your Honor.
Is that right, Mr. Reed?
That is correct.
All right, let's proceed then.
All right. So, Your Honor, the first two defenses are consideration defenses. Essentially, Eli Global's argument is that because the transaction where JTJ sold its business was to an affiliate of Eli Global, there is no consideration for the note whereby Eli Global agreed to pay JTJ $1 million. We've addressed this in prior summary judgment briefings, and we think this can be addressed pretty quickly. For one, a written contract is presumed to have consideration. Parties don't go around signing $1 million notes and then, of course, partially performing $1 million notes and paying $665,000 if there isn't a reason for the transaction, an exchange of promises. And of course, the other issue is the Hornbook law issue that one party can supply consideration for a contract that is between two other parties. So if I tell you that I'll give you $500 if you give your car to Mr. Reed, I can't turn around on the deal and say that there's no consideration for the transaction because I didn't get the car, Mr. Reed got it. Here, the note is included as part of the purchase price in the transaction, which is why my client did the deal and performed on the deal. So lack of consideration as an affirmative defense is out. That also affects the counterclaim. Eli Global's counterclaim is for unjust enrichment. It argues that because there was no consideration for the transaction, that JTJ should be compelled to return the money previously paid under the note, the two of the three payments that have been made. But of course, since there was consideration for the transaction, there's no basis for the unjust enrichment claim. The second consideration defense is failure of consideration, which, as we all understand, is slightly different than lack of consideration. In failure of consideration, the issue is whether or not the plaintiff failed to deliver some consideration that was a condition precedent or precursor to the defendant performing its obligations under the contract. Well, as an initial matter, under the note, the obligations are from Eli Global to make payment. There are no conditions precedent listed in the note. But even if you read the note and the APA as an integrated agreement, as we think of it, under the APA, the only consideration that my client was supposed to provide was the transfer of its assets, like its AR, receivables, et cetera. And it did that. There's no dispute that it did that. There's no evidence in the record that they failed to do that. There's no argument that they didn't comply with the asset transfers. I'm sorry, Your Honor, I see you speaking, but I can't hear
No,
you.
that's okay. Go ahead.
Okay. So as a result, there's not a failure of consideration. It is not as though there was a promise made that wasn't completed, and therefore the defendant's obligations to perform didn't arise. In fact, we know the assets were transferred, and we know the defendant's obligation to perform arose because it performed. For 2 years, it made the payments on the note. It was just in 2019, it decided to stop making payments on the note. So the consideration defenses, we think, are, along with the counterclaim, can kind of be evaluated together and can be denied because the note is presumed to have consideration for it, and we performed what we were supposed to perform under the agreement by transferring our assets. The final three affirmative defenses of fraud, estoppel, and prior material breach, those turn on the issue of whether or not JTJ made misrepresentations in the asset purchase agreement. And in its response, Eli Global alleged that there were two types of misrepresentations that had been violated. The first representation that they allege has been violated relates to...
Let's deal with the consideration first. Is this still part of the consideration argument?
No, Your Honor.
Okay, so let Mr. Reed respond. Thank you.
Thank you, Your Honor. Plaintiff would like the court to think that this is a simple note case when it's farthest from that. And what the plaintiff is asking this court to do is to grant as a matter of law that there's consideration, despite the fact that there's summary judgment evidence by the way of the affidavit of Mr. Hall showing that there was no consideration for this agreement. He's also asking the court to do something that he can't provide a single case showing that another court in Texas has done such a thing. When he says it's Hornbook law, the cases that he cites for this proposition are employment cases dealing with commissions and the like. He's not presented a case in which a alleged third-party entity is to pay a note in which the summary judgment evidence is that nothing went to Eli Global as a result of this contract. Their only argument is that by some way being an affiliate of that, but the summary judgment shows that that Eli Global is not the parent company of FTGU. And of course, Your Honor, right as we get going, the neighbor's lawn guys are blowing right here. I apologize.
That's okay. It happens to me all the time too. Don't worry about it.
It's
The
right
era of
outside
Zoom.
So hopefully he'll move here real quick. If you can still hear me here. Of course, it wasn't here for the past 40 minutes. It only happens when I start talking.
No worries. We can hear you fine.
But the summary judgment evidence in the affidavit of Mr. Hall before you is that Eli Global is not a parent corporation to FTGU and does not have a direct interest. And so there's just this argument without support out there that Eli Global received some kind of benefit as a result of this contract. But in fact, there's summary judgment evidence to the contrary, and at least a factual dispute here, Your Honor, that precludes the court from ruling as a matter of law.
I guess the way I look at this is clearly there is some type of consideration. So there's not a lack of consideration. I think it's a closer call on whether or not there was a failure of consideration, which was the consideration promised actually given. But clearly there is some consideration given, correct?
I would say no, Your Honor, because they can't point to anything that actually came to Eli Global. This isn't a note in which Eli Global got something and then it promised to pay over time in response for that. The summary judgment, the deposition testimony is that everything, if anything, if they did give anything, and then we have a dispute on what they gave and whether it was valuable and met the definitions of consideration. But if they did give anything, it went to FTGU. It didn't go to Eli Global. There's no evidence before this court that anything actually went to Eli Global in consideration of this agreement. What they're trying to do, Your Honor, and I think why this is trying to fit a square peg into a round hole, is that normally how these deals, and I've seen lots of these deals in which the proper way to do it would be a note with FTGU in exchange for assets or whatnot as part of a purchase that then is guaranteed by an affiliate or other entity. But that's not what they did here. If they had done that, then I think your argument might be right, Your Honor, if they were guaranteeing it. But there is no guarantee here. What they have is a note in which that is the only contract in which Eli Global is even a party to. They're not a party to the asset purchase agreement. They're not a signatory to the asset purchase agreement. And so, it's not the job of the court to fix a deal that wasn't done correctly at the outset. And it's not the job of the court to do something that's never been done, as far as I can tell, and to rule as a matter of law that there was consideration in which there's no evidence of anything going to Eli Global as a result of this note.
Okay, response.
Well, Your Honor, let's start here. There is a presumption that written contracts are supported by consideration. That is a legal presumption that favors the plaintiff and that the defendant, as the party with the burden of proof, has to overcome. You can't overcome that presumption by saying that the lawyer understands that in other contracts like this one, it's done differently. That's not summary judgment evidence. That's a theory about how the contract should have been structured in 2016. But second, the theory about how the contract should have been structured in 2016 is proof that there is consideration. because Eli Global is a big company. It comes to the table. Instead of insisting that the contract is structured the way Mr. Reed thinks it should have been structured, they voluntarily assume an obligation under $1 million note. Then they make the first payment under the note. Then they make the second payment under the note. Then they get sued and they wake up and go, man, we didn't receive anything under this note. Well, obviously they did. They received the assets that were transferred to their affiliate. They want to say they weren't a corporate parent. We don't need them to be a corporate parent. It was a direct obligation that they undertook. The guarantor relation example that he's giving is the exact reason why you can have a transaction supported by consideration, even if the defendant's not the one that receives the consideration. Take an example that we all know. If a parent guarantees a student loan for a child, they can't refuse to pay the loan on the grounds that they never went to Psychology 101. You can get consideration for a transaction the way that this was structured, and they did.
All right, I'm going to grant it on the lack of consideration. I'm going to take under advisement on the failure of consideration. Fraud and estoppel and prior breach, and we have about 10 minutes left for this. So each side's going to get 5 minutes.
Okay, Your Honor.
You can keep time.
So very quickly then, it's based on two misrepresentations, all three of these defenses. The first misrepresentation is a claim that JTJ misrepresented its client contracts. And in the APA, JTJ represented that each contract was binding and enforceable and that it had no actual knowledge that these contracts were going to be terminated. In response, Eli Global says, well, after the business was purchased, the business fell off a cliff, ergo there must have been wrongdoing. To be abundantly clear here, there is no evidence in the record, and I challenge Mr. Reed to identify any, that says that JTJ misrepresented anything about a client contract. They've simply said that because the business fell off a cliff, there must have been a misrepresentation. We know that's not true because there's summary judgment evidence, and we took pictures of it in our reply brief. It's at page 122 and 123 of their response, has a column that says reasons for termination. And no reason for termination includes any wrongdoing by JTJ, none. All of the reasons are garden variety things like the businesses taking their medical billing services in-house. The second misrepresentation is that JTJ claims, or I'm sorry, Eli Global claims that the asset purchase agreement required JTJ to have made disclosures about some personal issues related to JTJ's owners. The first issue being that two of the owners were at one time married, but divorced years prior to the asset purchase agreement. And then the other being that one of the owners, Mr. Torres, had a brief relationship with a subordinate. Now, there is nothing in the APA that compels that disclosure. There's no section of the APA that's cited in the response. And again, I would challenge Mr. Reed to identify a section of the APA that says we're required to have disclosed that. But even if we were required to disclose it, there is a section in the APA that provides that if claims for breaches of the representations in the agreement are not brought within 2 years, then those claims are waived. And this claim was not brought with, this fraud defense was not brought within 2 years, it's waived. Moreover, there's a provision that provides that they disclaimed reliance, which of course is an essential element of the fraud and estoppel defenses. They disclaimed reliance on any statements made outside of the contract or any statements not made explicitly inside of the contract. And if we enforce those, then each of these affirmative defenses gets dismissed. As to prior material breach, the only argument is that we breached the APA by making these misrepresentations before their obligation to pay the note arose. So if the court concludes, as it should, that Eli Global hasn't substantiated its burden of proof on the existence of these representations, then the prior material breach defense would have to be dismissed as well. And I think I used about 3 or 4 minutes, so if I can reserve whatever's left, I'd appreciate it.
How much time does he have left? 2 minutes. Okay.
Thank you.
Response.
Your Honor, the APA, which we have to jump through a lot of mental hoops to get there because Eli Global's not a party to it. But when we get to the fact of the failure of this consideration and how JTJ duped FTGU into this agreement, because we get the benefit of those if you're going to try to hold Eli Global liable for those obligations or the APA to which it was not a party. What JTJ represented in section in the APA, they represented that, and we've cited this in our brief here, Your Honor, that neither seller has knowledge of an existing or threatened occurrence, event, or development which would reasonably expected to have a material adverse effect. Mr. Hall's affidavit, with his knowledge in this area, has testified that they actually, we've discovered that they did withhold information of, and they definitely had knowledge of material adverse effect on the company, being the relationship of the management team and the divorce, the improper relationship with the employee by part of the owners and management team here at JTJ, which had a profound effect on the morale and the effect of this. And if they had known about this, then FTGU would not have paid the premium it had. There's also a representation within the agreement that no party to the contracts, and the contracts here, Your Honor, is what the assets of what they really transferred. And that's what the summary judgment evidence shows, that these contracts were really the heart and soul. The rest is, a little here and there, computers and whatnot, but the value is in the contracts. And they represented that none of these contracts intend to terminate or refuse to renew. And what's evidence of the fact that it was a false representations, the fact that over 50% of those, and we put that in the affidavit here, Your Honor, if I had more time, I could go detail by detail, but they did jump ship. And the idea that you have to, show that they admit to that they knew this beforehand. No, the jury can deduce that based upon the evidence and the testimony, which should happen here. And so it would be error to grant summary judgment on these affirmative offenses and not let them go to the jury should we not settle on Tuesday. So we have the representations, the fraud, the estoppel there, Your Honor, based upon in the prior material breach, based upon the fact that there is, and he challenges me to point it to, it's in our affidavit, that the sheer number of these contracts, and the evidence is that Mr. Hall testifying here is that this deal would not have gone through with FTGU had those representations been true. They cannot be true, Your Honor, when so many of these contracts are canceling that quick after the APA is signed. And that's in the province of the jury to decide, because we do have at least a scintilla to survive this summary judgment motion, Your Honor.
All right, 2 minutes.
Your Honor, may I share screen again? Sorry,
Okay.
I kind of already did. It'll just make things a little bit faster. So let's start with the challenge that they provide the evidence. All right. So if the court will look with me here to the top of page 7. So on the right, here's the only evidence in the Hall affidavit, paragraph 8. Clearly, JTJ's representations regarding the status of its client relationships and contracts was false. That is like a law school exam of what constitutes an inadmissible conclusory affidavit. Then, if you look back at the actual evidence that they supplied, I told you there's a column that says reason for termination. Their biggest client, they brought the contract in-house. That's in their evidence. Their second biggest client, we disclosed in Schedule 2.5 that the contract had been terminated. Their third biggest client, they say the contract was given to a former employee that started their own company. There is no evidence that we lied to them about any client contract, which is why we moved to have the fraud and estoppel defenses dismissed. As to this issue of the personal relationships, the simple thing there is a material adverse event is a development that affects the purchase price. It's not about history, it's about a development. The history is that these people divorced years prior to selling the business. So that's not a development that needs to be disclosed to Eli Global so they can decide what to pay. That is the past. If they wanted to know what personal relationships existed, they should have asked about them. Your Honor, the only other question I'd ask is that since you granted on lack of consideration, I believe the unjust enrichment counterclaim would be dismissed as well, And to the extent that the court's willing to rule on that or anything else today, just wanted to bring that to your attention.
Unjust enrichment. Okay, is that one of them too? Let me see.
I believe Your Honor.
I don't have that here, unjust enrichment.
If you scroll up to the top, it's before the chart, Your Honor. They've got a counterclaim for unjust enrichment that is separate and apart from the affirmative.
Right, that wouldn't apply, obviously, correct, Mr. Reed?
It would. I mean, that there was failure of consideration. I mean, the court hasn't ruled on that, so the failure of consideration would still enable us to recover on our unjust enrichment on those payments.
Well, Your Honor, all I'd say there is that the allegation for unjust enrichment, that as they allege it, is that there was no consideration. Eli Global received no consideration in connection with the note. And I think if the court finds that there was consideration received, then unjust enrichment is dismissed. And this becomes a question about whether or not we breached obligations under the contract, which we didn't.
All right, so let me go ahead and give my rulings. Thank you. Appreciate that. I'm going to go ahead and grant the summary judgment dismissing the counterclaim for unjust enrichment filed by defendant Eli Global. I'm going to grant the summary judgment as to lack of consideration, unclean hands, failure to mitigate, and justification. For the other four affirmative defenses, failure of consideration, fraud, estoppel, and prior material breach, the court is going to take those under advisement and get you a ruling within the next 3 weeks. All right, guys. Thank you. We just signed the order. You guys have a great day. You be safe out there, okay?
Thank you, Your Honor.
Thank you, Your Honor. Have a
Thank you.
great day.
All right, I don't really have a whole lot of time for this last hearing. We've already had a hearing once in this case today, so let's